All right, thanks everyone for being here. I think seems like most folks have gone through the system and joined at this point. So Sam, if you'd like to welcome everyone.
Okay, thank you. I'm Sam Issacharoff. I'm a law professor at NYU, and I'm one of the faculty directors of our Center on Civil Justice. It's a great pleasure to have you here. Unfortunately, Zoom doesn't convey the sense of excitement we have about this series. This was envisioned as a four-part series. It will be a four-part series on the new face of antitrust. It is something that was pushed very successfully by our directors and the chair of our board, Peter Zimroth and Sheila Birnbaum, who unfortunately can't be here today. But it was also really the support of two of the partners at Cravath, Swaine, and Moore that got this off the ground. Evan Chesler, and Catherine Forrest, who are both board members of our Center for Civil Justice. And the idea was to engage new issues in antitrust. The antitrust law seemed, even before the election, to be having a revival of sorts, having to confront different kinds of issues. And this first in the series is kind of an odd way to open, but it's a burning issue. It's the intersection between antitrust and democracy. And if you want to go back to the Sherman Act and you want to go back to the debates of the late 19th century, the two were always linked conceptually in the popular imagination. The idea of big trusts, big combinations was always seen as a threat to democratic governance. Well, today that takes a slightly different form because of the information society. And we have on the one hand, the concentration in tech, something that will be a big source of debates in the years coming forward, particularly just recently, Tim Wu of Columbia Law School, who's a primary critic, has now gone into the White House, and this will no doubt be a major part of his portfolio. But then we had the events of the last election, and the most amazing, just conceptual issue to deal with was that after January 6th, the temperature in the United States, the threat of violence, was apparently, in my view, provenly diminished by the decision of Twitter to remove the sitting president of the United States from his preferred means of communication. So you had tremendous private power denying the most powerful public figure in the country a forum, a means of communicating. This is a kind of an inversion of the First Amendment concern that government will shut down private actors. Now we had private actors shutting down the embodiment of the government, and many erstwhile champions of the First Amendment applauding this. So that's the topic. What's the relationship between this kind of extraordinary private concentration of power and how we conceptualize democracy, and particularly the relationship between private and public authority? So we have a great panel. I'm not going to do credit to the individuals. I'm just going to give their basics, because if not, I'll spend time on this. And I'll do it in the order in which we're speaking. Dan Rodriguez is an old friend of mine. He is formerly the dean of Northwestern Law School. He's taught at a number of law schools around the country and managed to hold jobs in some of them, I gather, and is a council member of the American Law Institute. He's a tremendous figure. And we're going to start with him and then move in sequence to Kate Klonick, who many of you may know from her wonderful writings about the internal Facebook processes, including an extraordinary article in the New Yorker. I recommend it to you all. Then Nate Persily, who's a Stanford law professor. Nate and I are co-authors. Nate is a genuine expert in not just the democratic process, but the intersection of democracy and tech. He lives out in Silicon Valley, so if he didn't have some tech creds, he would be completely useless out there. And finally, we will have Dina Srinivasan, who is a fellow at the Thurman Arnold Project at Yale, and who is an active litigator in the antitrust domain, particularly with regard to high tech. So with nothing further, Dan, why don't you begin? We're going to have each speaker go for about 7 minutes, and then we will go through discussions and take questions if those are sent in. Go ahead, Dan.
Sure. Thanks, Sam. Unless somebody shakes their head, apart from the merits, I'm going to assume you can hear me. And I want to begin by thanking three great institutions who brought this program, this series together. NYU Law School, certainly the law firm of Cravath. And for these purposes, I'll count Sam as an institution. So thanks for those three institutions for bringing this all together. I was asked to take just a few minutes to lay out some of the descriptive or doctrinal issues that deal with free speech and free expression as it pertains to big tech and Twitter. There are important normative issues, and Sam already mentioned them explicitly, and I know that all of us will get into those issues. But with respect to the doctrine and the description part, in some ways compared to the other panelists, I have a lighter lift. And the reason I have a lighter lift is, even though on the one hand, there are fascinating and important normative and even empirical issues that arise in connection with the concentration of private power, as Sam put it, and its impact on free speech, doctrinally, the case law is pretty well settled. I say that with some trepidation because, of course, 6 months can bring a new case law, but the law is pretty well settled at the two levels that I want to describe it. And they're different issues, although at the end, I'll come to see them as overlapping. One is, what can Twitter do, social media platforms, focus of Twitter as an example, or not do to restrict others? That's the paradigmatic example, of course, is what they did late in the Trump administration. But the general issue of what they can do to restrict, whether that's an absolute ban, it's flagging tweets, it's discriminating against certain tweets. The second issue is what can government do to them? That's the Section 230 decency issue and issues that arise in connection with their rights as speakers. So as to the first question, here's what I alluded to when I said a lighter lift. The basic answer is they can do, by and large, what they want. So saith the case law, despite quite a robust debate in the normative and the legal literature. And they can do so because of the classic line drawn between governmental action on the one hand, state action, as it's called, and private action. That, as a matter of American constitutional law, without getting into the weeds on this, reflects our long and storied and albeit somewhat controversial distinction that the Constitution makes and constitutional law makes between private action and state action. The rationales being really the twin rationale, number one, of the protection of private property. And while not absolute, the right to exclude, as it were, being one of the classic sticks in the bundle of property rights that individuals have to be protected against governmental intervention, including governmental restriction or regulation. And the second is the view about going all the way back to the framers and even before, that there are unique threats to democracy from state power that make it important to distinguish state action from individual and private action. In First Amendment or free speech doctrine, the lines have been drawn for many, many decades between governmental action and private action. There was more than a kerfuffle. There was some very important doctrinal activity going back to the 1940s in cases that many of you will have heard of, Marsh versus Alabama, in which the Supreme Court struck down government action, private action, on the theory that this was essentially a company town and that private action would be converted into government action. The Supreme Court in 1948 struck down racially restrictive covenants, even though entered into by two private parties, on the grounds that the governmental intervention constituted enough state action for the purpose of free speech. So I wasn't around then, but in the 40s, 50s, and into the 60s, there seemed to be the promise, or at least the prediction that many made, that these cases and other cases would efface the classic distinction between private action and state action, and we may be moving into an era in which governmental private activity that restricted speech, particularly, again, to go back to Sam's point, among institutions and actors that had concentration of private property, would reflect the kinds of threats that would give rise to the First Amendment. But that revolution never came. And so coming up to the present, even some of the cases that involve big tech in particular, and even cases that involve somewhat smaller tech, like the Supreme Court's decision in the Halleck case in 2019, which is not ancient history, but becomes a seminal case involving the distinction between governmental and private action. The Supreme Court has made crystal clear that there is a distinction, and a distinction that we will respect. And you don't have to take my word for it that Twitter, Google, YouTube, Facebook, the sovereigns of cyberspace, as someone called it many years ago, have had an unbreakable string of victories in claims brought against their restrictive activities on the grounds that they are private actors and not public actors. Just take the last year and a half. The Ninth Circuit, in a case involving YouTube, PragerU versus YouTube, ruled that the government that YouTube was not a private actor for the purposes, it was not a public actor, it was not a governmental actor for the purpose of free speech, and ruled in favor of YouTube. Freedom Watch lost a celebrated case brought against Google on the grounds that Google was discriminating against particular content on ideological grounds, and the court ruled, while Freedom Watch had standing, that this was private action and thus did not constitute public action for the purpose of the First Amendment. Tulsi Gabbard, if you remember her, lost a case against Google last year on the grounds that this was private action. And Twitter won a celebrated case in Wilson versus Twitter. What's remarkable about those four cases is half of them, two of them, were unpublished opinions, where the district court, the magistrate in the case of Wilson versus Twitter, DC Circuit in the case of Freedom Watch, thought it was unremarkable, sufficiently unremarkable as a doctrinal matter to even write an opinion, and cited and invoked Halleck as authority for the proposition that these actions were private and not public. The Halleck case involved Time Warner's ownership or non-ownership of cable TV in New York. It wasn't a big tech case. The Supreme Court wrote very broadly, and Justice Kavanaugh for the court said that Ben Franklin does not have to open up his stagecoach everyone when he runs a newspaper. Merely hosting speech by others is not a traditional exclusive public function and does not transform private entities into state actors. Even the dissenting opinion, and there was a dissenting opinion by 4 justices in that case, written by Justice Sotomayor, said in a footnote, "There was a time," and I quote, "when this court's precedents may have portended the kind of First Amendment liability for purely private property owners that the majority spends so much time rejecting. But the court soon staunched that trend." So it's just by way of summary, at the level of Twitter and big tech's bans or restrictions of other speech, seems rather clear that as a matter of First Amendment doctrine, that they would be regarded as private actors and not subject to free speech restrictions. I'll say very briefly on the second point, that is, what can government do to them? That the answer is also not a whole heck of a lot as a result of the statutory protection provided by Section 230, much to the chagrin of the previous administration. I suppose what I would raise, sort of as I come to the close of my remarks, is whether facts on the grounds could change. Leave aside, and by facts on the ground, I don't mean the Supreme Court justices changing their mind or new judges or justices being appointed. Could circumstances change so as to make the first argument, that is, that Twitter would be free to ban individuals without constitutional interference, and the second argument, that is, that Twitter and other big tech companies are largely immune from liability? Would certain facts on the ground change to modify that? I would say the answer to that is mostly no, but here's why I say mostly. There was some analysis in some of the cases I mentioned, particularly the Wilson versus Twitter case, the Freedom Watch versus Google case, that involved the question of whether or not these internet platforms are essentially public spaces or public accommodations, and so would come under the rubric of Title II of the Civil Rights Act. Now, it doesn't much matter, of course, as long as Section 230 is in operation, but if 230 was repealed, or if 230 was substantially modified, or along came an executive order like President Trump had that sought to narrow its scope, would there be an argument that these internet platforms would be public accommodations and public spaces for the purposes of Title II? And that answer is, that remains undecided. The DC Circuit said the answer to that is mostly no because of existing precedent in the circuit. Other circuits, including the First Circuit, have claimed that these are public accommodations in public spaces. So one question I'll just leave you with to ask is, in the face of the possible repeal of this particular statute, would it be possible that in the narrow but important context of discriminating against speakers and making decisions and choices that are not viewpoint neutral, are not content neutral, but actually would constitute some discrimination, would there potentially be liability under a theory that these internet platforms are essentially public accommodations, which probably a segue into what some of the other panelists will talk about in connection with antitrust. So I'll stop there.
Thanks, Dan. That was absolutely wonderful. And Kate, let me just transition by seeing if you want to pick up on this idea that facts on the ground may change. And in your New Yorker article, you cite the role of our former colleague, Noah Feldman, in convincing Facebook that they had to have something like a court because they needed to have some sense that there were processes, there was, if you will, due process, there was a sense of rule of law within their imperium. So tell us what's going on in these companies and how does that respond to Dan's invitation that maybe the facts on the ground will change?
Yeah, so absolutely. So a few things just kind of to respond to some things that Dan brought up, particularly a public accommodations analogy. So that's a great example of exactly how kind of I think the analogies in First Amendment tend to fall short in ways that are at first appealing to those of us who are reading something and thinking, okay, this is just a diner. This is just Facebook is just a Disney World. Facebook is just, they want to have and take off certain types of people and keep it their way. It doesn't matter. That's their right to do this. As long as they're not discriminating against certain protected categories, they're allowed to viewpoint discriminate. And the difficulty with applying public accommodation law is that the mechanisms by which we can sort out whether something is viewpoint discrimination or discrimination based on a protected characteristic is, of course, we can see people or we know people or we can discern that type of thing. And online, at the scale at which things function and because of the amount of anonymity, these things are very difficult to kind of do in practice. I kind of just want to take a step back. Everything that Dan was saying, I think was like a wonderful summary, but to give an idea of a little bit how we got here and to approach just kind of the regulatory environment that the US government created so that we have had this kind of immense area of growth in tech over the past, well, since 1996. I will just kind of give a brief summary of Section 230. And then kind of just bring it back around to kind of where we are today and like this public-private distinction in terms of speech. The environment in the early 90s online was one in which most people were using the internet to post onto message boards. This is something called user-generated content, but it is third-party content. It's content that's going up and that there's not an editor. No one is soliciting this content to be kind of put up on these boards. People are just posting it like as they would in a bulletin board outside their supermarket or something like that. Well, in a lot of places, there was starting to be litigation in these areas about whether or not this type of content should be the responsibility of whoever ran the bulletin board, right? As an intermediary, are you going to take down this type of content or are you going to basically allow it to stay up? And there were conflicting holdings that were coming out from courts. And there was also a lot of really nefarious content being posted online and just disfavorable content. Pornography was proliferating online. Spam was proliferating online. And so because the Communications Decency Act of 1996 was an effort by Congress to basically start to address this internet, to clean up the internet in all of these various ways. Section 230 was one provision of that. This entire law, besides Section 230, was struck down in 1999 in ACLU, Reno versus ACLU. But I just kind of wanted to point out what Section 230 did. It basically got around the difficult problem of regulating speech by incentivizing intermediaries to create standards and mechanisms in which to self-regulate and take down content. And if they did so, this is kind of the Good Samaritan provision, if they took down kind of lewd and lascivious content, they could basically avail themselves of an immunity from liability for third party posts that were made on the site. This doesn't apply to criminal activity. This doesn't apply to things that have been specifically named to be illegal, like CSAM, child sexual abuse material. But other types of content, it basically said to internet companies, listen, as you're going to be intermediaries, but we're not going to hold you liable. We're going to create this like bubble, essentially, for you to grow and to not have to deal with being basically sued out of existence because you have 10,000 messages on a message board and 2 of them are defamatory, and someone can sue you in much the same way someone would sue the New York Times or Hustler or something else. And so this is Section 230. This is what is at the crux of what's happening now. With all of the move towards trying to either amend Section 230, although it was recently kind of amended with Seston, Fosta, and the Sex Trafficking Acts, but basically a move towards maybe we don't want to continue to accept all of these tech companies from this type of liability. Maybe there are enough harms, and the harms have reached a great enough level that we want to be able to hold someone liable, whether it's through kind of a products liability type of thought or regime, or as state actors in that type of regime and a First Amendment type of standard. That's kind of where the conversation is. I tend to think that at a very the facts on the ground type of level, that you will see and increasingly see, and I'm interested to hear Dina's thoughts on this, that Facebook and Google are going to be pro repealing or getting rid of entirely Section 230, because frankly, they are big enough now that they don't need any type of shield from this type of liability anymore. They're able to fight it. They have good lawyers and lobbyists, and the law has come out strongly in their favor. What in fact you will see is that they know that if you get rid of Section 230 immunity for intermediaries, that smaller intermediaries will come into play. Other new types of companies and tech companies and platforms will come into play. And those will, in fact, if Section 230 doesn't exist, will make it very easy to get rid of smaller companies and to remove the incubation period that Google and Facebook and other places enjoyed. And so there's an interesting I think, misinformation around Section 230, which is that there's this belief that getting rid of Section 230 will bring some level of viewpoint neutrality to the internet, which I don't think it will. I think the First Amendment will still allow these private actors to create these spaces and to decide how they want their platform to publish certain types of material. I think, however, what you will find if you get rid of Section 230 is that it will exacerbate antitrust problems and the control of some of these higher level companies and the amount that they are subject to kind of suit. And so this is kind of this interesting wrinkle as people are coming into how the First Amendment interacts with all of the regulatory action that encourages self-regulation kind of structures that have been in place over the last 25 years. And I think that it's a really interesting question. And I think that we're basically, as Dan kind of really tilted at, and I couldn't agree with more, is that this line that we're very used to drawing between public and private is just disintegrating, and that there's no way of really understanding what a public forum is, what a public square is, what a public figure is, what the public is generally, vis-a-vis these intermediary spaces. And I think that it's frankly kind of actually intuitively turns a lot of First Amendment law on its head. So for example, I think that if you look at New York Times v. Sullivan and the political and the public speech doctrine, the kind of public figure doctrine that comes out of that and Gertz, I think that you'll find that that was the idea that you're going to have to show actual malice if you're a public figure to show you're going to have a higher burden in order to show that you were defamed in some way, and because you have more access to speech. And what we're seeing in the current cases is if you're a public figure, it doesn't matter how much you're censored. There is still going to be a way for you to get your message out there and for power to kind of recapitulate itself. And so I just think this is an interesting, that these are really interesting times for the First Amendment and for these these lines that we're drawing between public and private speech. And I will leave it there. And I think I'm handing it off to Nate.
Okay, so Nate, let me direct you a little bit. Kate introduced the idea of self-regulation as a form of self-protection. And we know that ever since King John made his agreement and allowed the Magna Carta in exchange for money and power to be still in his hands, that this is a long-standing tradition of you grant some rights. To what extent is are the internal reforms in the tech world now? And according to Kate's article, you've been a part of these discussions internal to some of these companies. To what extent is this an attempt to ward off either antitrust liability or other kinds of breakdowns of the public-private lines that we've seen? You're on the East Coast, we unmute.
Yes, yes. Well, now we'll see if I improve. I'm not sure. I'll say, first of all, I want to dispel a misconception here with that maybe from my Silicon Valley perch, I'm more sensitive than others, which is on these questions of democracy and platform power. The platforms do not want to have this responsibility. All right. Everybody thinks that Facebook really enjoys having hate speech, incitement, and controversial political content on its platform because somehow that leads to greater user engagement. That really is not the answer. That they would love to offload a lot of these very sensitive and difficult political decisions to some other body. They'd like the government to make a decision on much of this, but as I'll talk about in a second, if the government were to make these decisions, that would violate the First Amendment. So I think that, you know, it's important for people to understand that while particularly in elite circles like this, we focus on the political content on Facebook and other places, roughly 6% of the content in an average person's news feed is anything what we might call political or news even. That most of this is most of what people experience online on these platforms is you know, cat videos and social relationships and things like that. But let me quickly talk about what I think the limits and opportunities are for thinking about this from the antitrust perspective. I should say, by way of introduction, I was going to say, Sam, that you and I, you know, in some ways talking about antitrust and its relationship to these platforms, I feel like our relationship has come full circle over the 25 years that we've known each other. It sort of started as you and Rick Pildes were writing about antitrust and applying it to the law of democracy. And now we're starting to think about, particularly with respect to political parties. And now we're focusing on the other big actors that have developed since you wrote those influential articles, which are these tech companies and how they have an impact on democracy. And in part, you know, I think, as you said in your introduction, there is a recognition that the traditional way that we have been thinking about antitrust, traditional, which is to say since the 1970s Borkian revolution and antitrust focusing on consumer welfare and the like, is not responsive to the current dangers that big platforms play with respect to democracy. So as you said, either we go back to some more, I don't know, robust notion about big power and its effect on democracy, say at the turn of the century and the like, with trust busting, Brandeisian antitrust, or we really sort of deal with the antitrust democracy problem from the standpoint of the communication marketplace. And recognize that this is a different type of competition problem, right? That this is not the railroads, it's not oil, it's not airlines, it's about firms that regulate the marketplace of ideas and the threat that that poses to democratic deliberation, et cetera. Now, As I said, the way we have talked about antitrust has shortcomings when it comes to the platforms, for some of the reasons I mentioned, but also because the products are free, right? That it's not about the sort of the increased price that you're going to have to spend in order to do a search or be on Facebook or the like. There isn't any obvious economic loss or consumer welfare from these monopolies. And also some of the traditional tools like breaking up Facebook and Google, which I support for other reasons, but they're not really responsive to the democracy problem. Because if the power of Google is the search, the Google search, and the power of Facebook is the newsfeed, you really can't break those up, even if you were to try to break off, say, YouTube from Google, WhatsApp and Instagram from Facebook and the like. Now, that's not to say traditional antitrust conceptions don't have some role here. I think they're, preventing mergers, preventing, in the same way we might be worried about bigness in other settings, we could be worried about it here. But the antitrust or competition problem is very different for different firms. So Amazon is different than Apple, which is different than Google, which is different from Facebook. And something we haven't even talked about yet, which is where on the stack of the internet do we see the problem, right? Because in addition to thinking about Twitter taking off Trump and the like, you have the problem of the App Store and Apple taking down Parler. You have the problem of Amazon Web Services not hosting Parler or other types of media sites like that, right? And so there's all these other kind of lurking antitrust problems that are sort of related to sort of traditional doctrine here, but are not, don't logically follow it. And I should say that the way when we talk about antitrust in the platforms, a lot of the discussion is viewing antitrust as the way to punish the platforms, right? And I think there are reasons to punish the platforms, but it's not clear that antitrust is the right way to do it. So what is the democracy problem? As Sam and Dan and Kate all said, that Facebook and Google in particular have this remarkable power over the speech marketplace. Their community standards are as important as formal law. They set the rules for elections and political advertising. Nick Clegg, the VP of Facebook, is fond of saying about 2 years ago, he went to the European Union to declare what the rules would be for the European parliamentary elections, right? So a leader of a US company was going there to declare what the rules were going to be for political advertising and the like. This comes up, of course, as in this last go around in the US, is to take down in content moderation policies, but also in how they deal with fact checking, and in particular, the algorithmic decisions that these platforms make as to how to prioritize some speech over others. Because as we've learned, right, when especially as conservatives worry about shadow banning and the like, that as my colleague Renee DeRessa here at Stanford says, freedom of reach, right, can be as significant as freedom of speech here. And so as Dan said, the platforms are both rights holders, see Citizens United about corporate speech rights, as well as rights regulators in that they control the political marketplace. Now, we are in desperate need of democratically legitimate government standards to deal with these problems. But as I said earlier, if you were to come up with standards related to hate speech or disinformation that were government sponsored, they would in the US be unconstitutional, and as well as violating international human rights standards in many other parts of the world. As Kate mentioned, a lot of the effort then is focused on thinking about CDA 230, this as being a boon to the tech companies that creates this problem. For reasons she explained, I think that it is a distraction, but also CDA 230, you may want to reform CDA 230 for lots of different reasons, but it doesn't solve your democracy problem. It doesn't solve the problem, not only of the platform power problem, but it will not lead to dealing with issues of platform bias. It will not lead to dealing with issues of disinformation and hate speech, right? So CDA 230 is, I think, more of a metaphor for how we talk about tech regulation as opposed to an actual substantive policy to deal with some of these pathologies. To pick up on what Dan had said about thinking of these these settings, these platforms as public accommodations or the public square. I think that is a very familiar way that we are talking about this, and in fact, even Justice Kennedy does so in a famous case dealing with basically the rights of someone to whether a criminal can be prevented from going on social media as part of their punishment. And when we talk about the new public square, and even Zuckerberg and some others talk about it this way, I think that is the wrong way to think about this. These are highly regulated environments. All of the community standards that Facebook, Google, Twitter have would be unconstitutional if they were legislated as formal law. In addition, the most important decisions that these firms make are as what occurs at the top of the newsfeed as opposed to what is at the bottom. That is a very different set of analyses as to who can speak in the public square in the Boston Commons or the like. And so if you just sort of unpeel the onion here a little bit and start thinking about what it would be like if the platforms applied the First Amendment to the speakers on their platform, it would become totally unmanageable. All of their rules with respect to nudity, with respect to obscenity, with respect to bullying, with respect to spam, all of that would be illegal. And so you need to find some other set of rules in order to deal with them. In addition, as you start thinking about the regulatory options, you realize if what I said is true, that the power of the algorithms is actually the thing that's most important, that is extremely hard to regulate. I can tell you there is no single person at either Facebook or Google who actually understands the algorithm either for search or for newsfeed. Many of these decisions were made years ago, and the people are no longer at the firm. The Google search algorithm has changed over 1,000 times per year, and it with machine learning and the like, it's not even clear that individuals are making some of these decisions. And so what are the options going forward that people talk about to deal with this problem of platform power, unaccountability, and its effect on democracy? Some argue for some kind of quasi-public-private partnership along the lines of the FINRA model, dealing with Wall Street and the like, where you'd have some kind of blessed private group. That's challenging given the area of free speech that we're talking about. Some would point to, say, a motion picture association model where you have the industry sort of coming together to develop some practices and standards here. Our colleague Evelyn Dueck, I think, raises some good objections to that model, and worrying about what she calls content cartels, that do you really want the same rules to apply to Twitter, Facebook, and Google, let alone to Pinterest and Reddit, 4chan, and the like. And so where we at Stanford have been doing a lot of the investigation is thinking about what we call middleware solutions to deal with the problem of the platform, the sort of data monopolies and their ability to both, on the one hand, have this audience and to feed them content, but also to try to create a market for content moderation and algorithms, so that a whole new set of firms might be able to compete over the priority of the information that you see in your newsfeed, as well as what the content moderation rules will be. Now, there are challenges in doing that. Among them, this does beg the kind of Cambridge Analytica problem. As you allow other firms to sort of ride on the data that Facebook and Google have about you, it causes real challenges. But I think that is the future. Twitter, Jack Dorsey has expressed some interest in this. And it has to be, that in the future we'll have maybe not competition directly with Facebook and Google over their sort of primary business practices, or even in the advertising market where they really do have monopolies, but to try to develop a new market that is directly dealing with this democracy and content moderation problem.
Thanks a lot, Nate. That was great. Before we go to Dina, I'm supposed to read the CLE code. It is all caps CCJAT10. CCJAT10. Okay, Dina, so I learned my antitrust in law school from Robert Bork and Ralph Winter. And so I believe in consumer welfare. I learned that this Brandeisian notion is some crazy romantic sense of the late 19th century that no serious person could take seriously. So where's antitrust kick in here? Does it have a democracy component? Are any of these issues redressable through antitrust law?
Sure, thanks, Sam. And maybe before I just start, I'll respond to Kate's question. Kate, you had asked whether I might agree that sort of repealing 230 would, give Facebook and Google a get out of jail free card. I hadn't really thought about it, but I do think it's true. If you have to build algorithms to sort of avoid liability in the absence of 230, Google and Facebook would be uniquely positioned given their sort of vast troves of user data and historical data to build those types of effective algorithms. So on to your question, Sam. Well, I will say that I think I'm a little bit biased here. I tend to think about everything from a product perspective and a consumer perspective. And in part, this is probably because I just used to be an entrepreneur and used to work in the business world. And so when I see products around me that are sort of breaking or not working great for the consumer, right? I ask why, and I become terribly curious as to why there are problems with the product. And this was one thing that I very much sort of became curious about with Facebook in around 2010, 2012, 2014. You had the Snowden revelations come out that alleged that sort of the federal government was tapping into users' data through the PRISM program. You had Google and Facebook in this runaway market collecting a lot of user data. And then I was in the advertising industry at the time in 2014, and I noticed that Facebook did something in the advertising industry, which everybody just sort of started throwing confetti about. They announced that they would start tracking consumers across the entire internet that has Facebook like buttons or any kind of other Facebook code or Facebook SDK on mobile phones. And they would basically get consumers to consent to that practice and then use that data to juice their advertising algos and to sell more advertising. And Facebook was like the only firm that could extract this type of permission from the user to sort of track them across the internet, tie it with their real identity, right? Because you have to log into Facebook with your real identity and then sell advertising against it. And whenever you see sort of a very competitive market and only one firm able to extract something from consumers, having studied antitrust law and read Bork and studied the consumer welfare standard, the light bulb went off for me and I was like, well, this looks like, it's not consumer welfare and something is breaking in this free market. And so what you realize, and by the way, just to say that this is also related to other democracy harms because, what was Cambridge Analytica about? Cambridge Analytica was about a firm in the UK that got access to a bunch of citizens' data from Facebook. And so the question goes back to, well, why does Facebook have this data in the first place? Why can they track users across the internet by their real identity? Why can they then combine that with their sort of profiles on users and sell more advertising? And if you go back and you just study the market, you realize that, incredibly, Facebook entered the market in 2004, competing on privacy against MySpace. They tried explicitly to get consumers to consent to having Facebook track them across the internet in 2006, again, a few years later. And each time they tried to do this over the next 10 years, consumers sort of revolted and, organized protests, and Zuckerberg, stepped back and said, we're sorry, Facebook is not going to do this. And so, you move through time and Facebook is competing on privacy, making explicit promises with regards to its intentions around consumer privacy. It's a market with strong network effects. The market tips in Facebook's favor, locks in. And then the same month that Google announces they're going to exit the social network market in June of 2014, Facebook flips the switch and says, we change our mind. We're actually going to extract that promise from a privacy perspective that we've been promising for 10 years we're not going to do. And so this to me looks like a very classic antitrust consumer welfare problem. And I look at the antitrust suit that the 48 AGs led by New York filed against Facebook. And I think, it's incredible. Like, this is a zero price market. Facebook has never charged a price for use of its social network. And you have 48 attorneys general that have basically come together and agreed to defend a citizen's privacy in this market. So I guess I would say that at least when it comes to the topic of the intersection of antitrust and democracy, that's one of the things that's going on. It's the collection of data. The collection of data gives these platforms tremendous amount of power that they can feed into these algorithms to do funky things and cause, harmful outcomes. The other thing that I would say, and I only have, I guess, a couple of minutes left, is we can talk about, middleware solutions, and I highly recommend the paper that Stanford put out on this topic. It's a very good read. But the other thing that we can do here is just look at the firms and what they've done in the past too, because those provide a lot of real examples and hard examples of how they themselves enabled competition. So I'll just touch on a few examples here. It used to be that you used to be able to send a message from WhatsApp to AOL sort of ICQ comparable messaging service, right? So that enabled you to use the platform of your choice, me to use the platform of my choice, and for us to still communicate with each other. And you can't do that today because Facebook sort of took down those interoperability standards that it itself had set up. Another example is you used to be able to post a message on Twitter and actually have it distribute on Facebook. So you also had message interoperability between these firms. That's my timer. Basically, when we're trying to invent things in the market and invent tech, I think it gets a little bit controversial, and we can add to that and be less controversial by just going back to their interoperability standards that they themselves have used in the market. Thank you, Sam.
Thanks. So Dan, you were really the only one who kept to time, so you got a bad deal. So let me ask you a question first, which is, take what we just heard from the other speakers. So there's portability, there's all these issues which sound a little bit to me like regulations that have survived First Amendment claims with regard to the telephone companies, with regard to cell phone companies, within all sorts of areas where there is a compelling enough government, a rational regulatory interest. If that's true, could privacy, the way that Dina laid it out, be that kind of compelling interest that allows one to overcome the First Amendment barriers here, especially when you have this kind of concentration of power?
So let me take the easy part. If by overcoming First Amendment barriers, the question is, would the government have the stature and the ability to engage in regulation, let's call it even heavy regulation? The answer would have to be yes. So that on the one hand, let's do by analogy to big media, old-fashioned media. On the one hand, the newspaper, New York Times versus Sullivan et al. Provides, if not sacrosanct, a sacrosanct role for newspapers, a heavy thumb on the scale for freedom of the press. That doesn't mean, on the other hand, the government isn't actively involved in the regulation of the public sphere in newspapers, regulation of the public spheres in the broadcast network, et cetera, et cetera. So by analogy, absolutely, the government has an extraordinarily important power and authority. Indeed, I would suggest, along with all the other panelists, an obligation to do so. The question, of course, is in the weeds of what kind of restrictions and regulations can it do. So when I hear Nate talk on behalf of Stanford's really remarkably sophisticated and interesting proposal for middleware, I'm left to ask the question is, why doesn't that just reinstantiate the problems with respect to the opacity of algorithms and information and all of that? So it seems to me we're at a fork in the road. Either the answer is, and I took Nate to make this point, which is, hey, get used to it, get over it. The notion that algorithms are going to be transparent and you can unpack the black box, whatever, that's not the genesis of the middleware proposals. We may not know how it works, and effectively, it may be the ghost in the machine, but that can be an effective mediating institution. And I think as a matter of regulation, to come back to your question, that survives First Amendment scrutiny without breaking a sweat. On the other hand, if the middleware solutions really involve opening the black box of the functioning of these institutions, then it's like the debate about Apple giving away its code. And it's basically requiring them to engage in significant, heavy-handed regulation of editorial content. And if that's what the solution is, then I think you're right smack in the middle of classic traditional free speech doctrine. And companies, big or medium size, are on very strong ground to resist that kind of regulation, given free speech protections and private property protections, et cetera.
Right. So the reason I asked you first is I wanted the classic kind of First Amendment doctrinal response. And what I'm hearing from the other three speakers is they don't really believe that these analogies hold conceptually for all sorts of technical and social reasons. And so there's a great deal of skepticism about whether any of this First Amendment tradition can be brought to earth in this domain. So Nate, I saw you wanted to say something on this.
Yeah, well, I mean, there's several things that we're talking about at once here. So first of all, you can look, privacy regulation should be done because of privacy regulation. There's all kinds of reasons that we should go in that direction. There is a trade-off that for the reasons that Kate was articulating about eliminating CDA 230 and how that emboldens the powerful firms. That is also true about privacy law, which is that you can't, depending on how you craft these privacy laws, it's the small competitors who need to come up with new ways of gathering data for targeted advertising that are going to be uniquely hobbled, right? So Facebook, for example, is more than happy to comply with GDPR, right? But the smaller firms are the ones who are going to have very difficult time getting up. Also, I agree with what Dina was saying about, going and looking at the sort of features that they have turned off that had interoperability before. And I think that's an important move. What I would say about the middleware solution, the point here is that this is another area where antitrust and privacy come up against each other, because the only way you are going to have competition on these democracy relevant questions of how to prioritize content in people's news feeds, as well as maybe the content moderation rules, is if you allow some other firm to determine the order of information that these other firms would otherwise be providing you, right? And that does require that they have some way of riding on and exploiting the data that these firms have. Last point is on what Dan was saying about the algorithms. I think there is a constitutional way to provide for algorithmic accountability here, and that you could have some way of making sure that we understand how these algorithms work in better ways than we do now. Algorithmic transparency, which a lot of people argue for, I don't even know what that looks like, frankly, because no one can, you can't be transparent about the algorithm in, like here's 2 billion lines of code, here, you figure it out, right? That's sort of not, doesn't have a lot of promise, but you could have a government body that kicks the tires, or in a sense measures the smog coming out of the tailpipe of these platforms and does certain types of tests to see how the algorithms, for example, lead to radicalization or prioritize certain types of content as opposed to others.
Nate, let me press you. Can I just take 1 second? Why is that middleware solution any different than when the Boston Globe continues to reject my anti-Tom Brady editorials over and over and over again? And I have no way of knowing it's because they want to protect Tom Brady, or I've published plenty on my own, or it's poorly written. Why is it any different than requiring the New York Times to basically explain their editorial policies that lead them to reject my op-eds or not my reject op-eds, which I think we would all agree would be anathema to any notion of free speech. We would never require them to disclose that information. Why is that different than what you're proposing for big tech?
Yeah, I'm not positive I understand why you think that analogy works here. I mean, the question is whether you can force the large platforms to allow other types of institutions to not necessarily to organize, to sort of invade Facebook's environment and invade Twitter's environment, but to then be able to otherwise organize your newsfeed in different ways than Facebook would require. Now, look, you're right. If you think about Facebook and Google as having free speech rights in the algorithm, and Eugene Volokh has a famous article years ago on this, then yes, you know, and you think about them as, you know, can someone come in, forget about even rejecting your op-ed, can you force, you know, the New York Times webpage to allow me to organize the articles on it? Yeah, then of course that's a First Amendment problem. But I think that there's a possibility. The point here is not that you're going to deprive Facebook of its ability to do that. It's just whether another firm might be able to compete in offering you options as a user to organize the feed in the way you
let me shift this over a little bit, because we have a bunch of questions from the audience. So Kate and Dina, let me meld some questions together. And it's a constant problem in regulatory theory that the more you increase regulation, you have the paradoxical effect of creating barriers to entry for small firms that can't internalize the cost of the big regulatory environment. So a lot of the debate is over 230, and because people want to hold these platforms accountable. And both of you are saying, be careful what you wish for here, because you may have the paradoxical effect of increasing monopolization as a result. So there's a number of questions that all kind of look like that. What do you all think of that? Either one, whoever wants to speak first. Kate, I see you. Go ahead.
I mean, I think that I think that that's generally correct. I would say that there's one other thing that we haven't talked about, which is kind of the safety and harm issue side of this equation in speech, and that kind of Nate got to with this idea of why we're so upset right now that these tech companies are so powerful. And I think that antitrust ends up becoming this, not easy, because I think very few people actually understand it, probably myself included, as much as I should. But certainly something that people can bandy about, the idea that these are monopolies because they are just so large, and there's all of these things that they control, and all of these different smaller corporations that are all owned by Facebook, and they have this much reach in everything they do. But going at these companies from an antitrust perspective doesn't necessarily solve in any way the problems that we have with these companies monopolizing our news feed, or monopolizing our access to certain types of information, or gatekeeping our information ecosystem, right? The ability of splitting off, it's not clear to me by any means that taking Instagram and WhatsApp and Oculus and splitting them off from each other is going to have any solution to the fact that we see incitements to violence, that we still see child sexual abuse material, that people are still bullied into suicide, like that these types of harms are existing in increasing numbers because of some of the things that the internet provides and these platforms provide. And so I think that there's just seems to be like a disconnect here in my mind between, is like Nate kind of said, peel the onion back and start thinking about what this will actually get you if you hold them to a First Amendment standard, if you get rid of Section 230. Think about whether it entrenches certain types of platforms or worsens your problems with power and monopoly. And I just don't see, so in particular, I don't understand how antitrust on privacy issues and breaking up Facebook in some way or another, if you break up all of Facebook and throw it to the wind, there will be another Facebook, and we will have very much, I believe, the same process that we have had now really painfully over the last 15 years. And at the very least, we are getting to a point where Facebook takes down massive amounts of child sexual abuse material and works with, like, does a great job in certain areas in trying to keep harmful material down from the internet. Fails utterly in other regards. But I just think that it's not clear to me the one-to-one necessarily between some of these antitrust provisions on privacy and what they will end up having downstream effects on speech or increasing harms for people.
So Dina, you're going to get the last word. And I found your comments fascinating because you tried to bring this back into the language of consumer welfare, which is where, you know, I feel most at home in this kind of analysis. But the question that Kate poses about whether any of the antitrust inroads and the potential remedies will really address the questions that we're concerned about, which is the kind of network externalities that promotes ease of communication of information, the difficulty of regulating in this massive environment. So how, as an antitrust person, how do you worry about the paradoxical effects of entrenchment and just basically missing where the consumer welfare concerns are?
Well, I don't think so. While the attorneys general and FTC case against Facebook, for example, focuses on the acquisitions as illegal acquisitions, I don't think that those cases are precluded from a remedy perspective from things that would require interoperability, message interoperability, things like that. So I do agree that if we, tomorrow split up Facebook from WhatsApp and Instagram, I, as a user, am just going to keep using Facebook, WhatsApp, and Instagram for the 3 different purposes that I currently use them for. And that does nothing. I think it's beneficial because it creates other competitors in the market that have large user bases that might start competing with each other. But we do need other things like interoperability standards that would help drive competition in these sort of specific markets. That is to say, for example, if Twitter deplatformed Trump, but Trump had message interoperability with 10 different platforms, maybe that would be a good angle to solve that type of problem in the market. The other thing that I would say, and we haven't really talked about this, but there is sort of the industry of news and journalism, and that's connected to democracy. And the case filed by a different group, there's another case filed by a different group of attorneys general against Google and what Google's doing in advertising markets. And I've written and done a little bit of research here, and that brings up in a very big way the topic of regulation and the intersection even between regulation and antitrust remedies, because that market looks very familiar when you start to dig into it. Almost all of Google's money revenue comes from selling online ads, and all of those ads just trade in milliseconds on centralized trading venues that are modeled on financial exchanges, and that Google has gone out to the market and said, hey, look, come trade on our exchange. It's just like the New York Stock Exchange. And by the way, also come trade through our brokers that are, like financial brokers. And a lot of the things that Google is doing to distort competition in that market, very similar to things in financial markets like front running or insider trading that we just outright prohibit. And we've carried those regulatory principles to other markets like betting markets or gaming markets. And the cryptocurrency market is starting to self-regulate around these principles. And the ads market is really a wild west, which is why Google's able to sort of concentrate so much economic power in those markets.
Well, unfortunately, we've come to the end of our hour. I have to criticize the panelists because I don't think you've resolved the issue for the audience that wanted a nice, clean answer to everything. And I may have missed that answer along the way. Dan Rodriguez just wrote that the Stanford white paper that Nate quotes from also has the line, private power faces no checks like popular elections. I think that's a nice little summary, because what we're asking is whether popular elections continue to serve as a check in this kind of environment. And so let me just say thank you to all of you. It was great that you could be here. One of the bizarre advantages of pandemic life is we have a big audience that's as bored as the rest of us and willing to watch anything, but we also have the ability to bring in people from all over the country pretty seamlessly. And so this was just spectacular. Thank you all very much.
Thank you for coming. We are going to be sending out an email sometime probably in the next 24 to 36 hours that will include a form to return if you want CLE credit. It will also include a preview of the recording of this event, which we'll eventually have on our website. For those of you who missed the CLE code, I'll just say, give you a little hint, it's at around going to be around at the 40-minute mark in the recording if you want to go back and look for it. So you don't have to rewatch the whole thing if you missed it. With that, again, thank you so much to Sam for moderating and for all your work for CCJ, and to the rest of the panelists for being here. And of course, the Cravath firm for helping conceive of this, put it together, and work with us throughout the whole process. We really appreciate everyone taking the time to be here today. And hopefully we will see you in 2 weeks, Wednesday, March 24th, also at 1 p.m. We're going to be having our next panel in the series, which will be on big data as a potential barrier to entry. We'll also be having events on April 7th and April 21st, also 1 p.m. to 2 p.m. Hopefully we will see you again very soon.
Bye-bye.